Good morning, members of the media, and good morning to all conference who will be listening when there is a broadcast. I'd first like to thank you for accepting the invitation to attend this media conference. This is a very important media conference because it concerns the behavior and conduct of a state-owned corporation, Petrotrin. As you would see from the information and evidence I would produce to you this morning, which we have recently obtained and we have seen constitute part of the record of Petrotrin. It shows that this state-owned company did not have any basis for terminating the contract with A.N. The evidence would show that it relied on inaccurate and unreliable data. I would show you this morning that from its own audit report, which we have seen, Petrotrin was warned that the data which it was relying upon to consider terminating the contract with A.N. was inaccurate and unreliable. I would show you this morning that even after the contract was terminated, Petrotrin commissioned reports, and based on the contents of those reports, it had a duty to restore the contract with A.N. Now, this matter is due to be heard before arbitrators in January. And because of the great damage which has been done to the reputation of A.N. and its owners and the members of the family of the owners, I believe it was a grave injustice for us to have this information in our possession and do not give the public the benefit of knowing this information so that they would know what happened, but also it can be used in some way to appease the damage which has been done to this company and which has been done to its CEO, Mr. Hanif Baksh, and the owners of A.N. But before I do that, I want to introduce you to members of the legal team, members who have been appearing on behalf of Mr. Baksh and on behalf of A.N. I would try to do this in a certain order. I would first like to introduce you to Mr. Jagdev Singh. I think you would know him. He is a well-known attorney at law in Trinidad and Tobago, and I would ask him to come and just say a few words.
Good morning, members of the media, all the listeners and viewers. Thank you for attending this morning's conference. I appear together with Mr. Maraj in the defense of both Mr. Baksh and his son-in-law, Mr. Ram Sundar, in the case of the Superior Magistrates Court, which comes up for hearing sometime early next month. And I just want to say that I came into those proceedings on the second round, where I believe that the relaying of those charges is wrong. So thank you very much. That's all I want to say.
Thank you very much, Mr. Jagdev Singh. I would now like to call to the microphone a person that I think everybody in Trinidad and Tobago would know, Mr. Prakash Ramadan.
Thank you, Mr. Raj. Good morning, everyone. Many have asked why that I would have involved myself. I am of the view, like most citizens, that our presumption of innocence in our Constitution must be respected. And I saw almost an attack on a citizen, notwithstanding who he is, in a way that presumed guilt in a criminal matter. And if for any other reason, that I think is the most significant issue that I have involved myself in this matter with. we are all entitled to the presumption of innocence, no matter who you are in this country. I've heard allegations, and Mr. Maraj will speak to this in relation to the arbitration and the false information that may have been given. I believe in due process, and that is why my colleague Mr. Singh, Mr. Ruplal, and of course our dear Singh and Mr. Maraj has always stood for every citizen, whether they're high or low in society. And there seems to be developed in this country a belief that once you occupy a certain level in society, that you can do no right, and that everything you do is seen through the lens of corruption and improper motives, and that you are not entitled to justice. Mr. Maraj, I congratulate you for this press conference so that we put things in order, because too often we hear rumors, we hear allegations, and people form a view that a person is guilty without due process. So I thank you. Thank you very much.
In order, I'm beginning first with the criminal charges. I'll call Mr. Michael Ruplal, senior law.
Morning everyone, members of the media, listeners, viewers, everyone present today. I think both Mr. Singh and Mr. Ramda have said a lot. I've been involved in this matter since inception, since Mr. Baksh and Mr. Ramsundar were both charged in 2017, and going through that process with them. What I can say, and I'm looking forward to the press conference and what Senior has to say this morning, but what can I say from my own knowledge is that this appears to be, an orchestrated persecution of Mr. Baksh and his family. And like my colleagues and everyone here, I'm sure, we look forward to bringing finality to all of these proceedings, both the civil proceedings, the arbitration and criminal proceedings, so there can be vindication of Mr. Baksh and his family. So thank you very much.
Thank you very much. The next person is Mr. Ronnie Bisessa. He is an attorney at law. He has been helping me and the legal team in respect of all the matters with Mr. Baksh, but in particular with the arbitration proceedings which are due to be heard, and with the attempts which we have made to get Petrotrin to do justice. Mr. Ronnie Bisessa is part of a legal team, and I should let you know that when I saw the injustice which was being done to Mr. Baksh by Petrotrin, I decided that I would move every stone in order to prove to the country that Mr. Baksh and A.N was totally innocent of the allegation. I call Mr. Ronnie Bisessa.
Thank you very much, Mr. Maraj, for that introduction. I am Mr. Maraj's junior in respect of the arbitration proceedings which are going to be convened in January 2020. Ordinarily, arbitration proceedings are private and confidential between the parties. This matter, however, has a very public character element. On the 9th of November 2017, Petrotrin issued a media release saying to everyone that the internal audit report and its findings were confirmed by various independent reports. That, unfortunately, was a completely inaccurate and unreliable statement. And having raised the matter in the public domain, it's only appropriate that A&V uses the public domain to be able to correct it. I'm very happy to be part of this team, and I feel fortified that what Mr. Maraj is presenting to you today would demonstrate that unequivocally and unambiguously that A&V has been ill-treated by them. Thank you very much.
Thank you very much, gentlemen. I would first like to start by saying that the facts of the case in which Petrotrin has terminated the contract with A&V, the oil producing contract which A&V had with Petrotrin, reminds me of a case which I took up when I was a much younger lawyer. And that was in 1975. In 1975, Texaco decided to, they had a case, there was a case against Texaco in respect of a fire on the Pointe-a-Pierre River. 4 persons lost their homes, and we had this case in court. And the judge threw out the case without a hearing. But on the facts of the case also, Texaco, as it was then named, were using the court process to really put pressure on these poor people. And I decided that whatever it takes, that I would ensure that those people who lost their homes on the banks of the Pointe-a-Pierre River would get justice. In that struggle, I had to have a quarrel with the judge, Justice Sunny Maraj, and I accused him of unjudicial conduct. And he jailed me for 7 days simple imprisonment. And that contempt conviction was reversed by the Privy Council after a long battle. And I refused to apologize to the judge. But at the end, I saw that not only the people got justice who had lost their homes, but the legal profession got justice, because my stand was a stand for the independence and fearlessness of the legal profession, because lawyers must not be sycophants and subservient to judges. They must stand up for their clients. They must also stand up to governments, stand up to state corporations if they're doing injustice to people. Well, the purpose of this press conference is really to try to make the public understand what has happened with this A&V oil contract. Now, to give you a little idea, as some background to what I'm going to tell you, A&V had a contract with Petrotrin. A&V had to drill and produce crude oil and supply to Petrotrin. Petrotrin would pay for that oil. Petrotrin decided that based on its measurement system, not on actual evidence, it had no actual evidence that A&V was involved in any fraudulent activity, but based on its measurement system of how it received the oil, and it received oil from other independent operators, Petrotrin assumed that since A&V was producing a lot of oil, that A&V overstated its production of the oil to Petrotrin. And it assumed and it inferred and it implied that A&V inflated its supply of oil to Petrotrin. And that is how these allegations of fake oil came into play, not on the basis of actual evidence, but on the basis of what Petrotrin assumed. Now I want to tell you in this matter, there is no question of fake oil. This is a case of A&V supplying real crude oil. And this is a case of Petrotrin having a fake defense to use fake oil as a means of trying not to pay A&V. So let me see how I can explain this to you. Petrotrin had a contract with A&V, as I said, for A&V to sell Petrotrin crude oil. There was an internal audit report prepared by the audit department of Petrotrin, in which the data stated that A&V overstated the volume of crude oil it sold to Petrotrin. Based on the contents of that report, Petrotrin started to withhold payments which were due to A&V for A&V supplying the oil to Petrotrin. A few days later, after Petrotrin got sight of that internal audit report, a supplemental internal audit report, which was prepared by the audit department of Petrotrin and which was submitted to Petrotrin, stated that the data which the internal audit report had and which formed the basis of the findings against A&V were inaccurate and unreliable. So a few days after Petrotrin got the internal audit report, there was another report from the audit department called a supplemental internal audit report stating that the data in that report, the first report, was inaccurate and unreliable. The supplemental internal audit report concluded that the measurement system and the measurement procedures of crude oil which Petrotrin used when independent contractors sold oil to Petrotrin were wholly inaccurate and unreliable. The audit department of Petrotrin stated that Petrotrin did not comply with the standard operating procedures in measuring the oil. Some of the contents of the internal audit report were published by the political leader of the opposition at a political meeting on the 10th of September 2017. Those statements allege, among other things, that A&B supplied fake oil to Petrotrin. Based on that internal audit report, obviously the leader was basing her comments on the internal audit report, and based on that report, A&B would have fraudulently collected $95 million because it overstated the volume of crude oil it sold to Petrotrin. So you would see that serious allegations were being made against A&B, and you would have thought that Petrotrin had a duty in respect of these serious allegations being made public to ensure that it conducted proper inquiries before it made a finding against A&B. These statements, which were made to the public, caused other persons in the public to make defamatory statements against A&B. And those defamatory statements have caused irreparable damage to the company, its business reputation, and the personal reputation of the owners and members and the family of the owners. The reports and information which Petrotrin has in its possession now have been seen recently by A&B lawyers, and they demonstrate that Petrotrin ought not to have terminated the contract. And I will go into some of this information with you. This information also shows that Petrotrin, after the contract was terminated, requested reports from its engineers and experts and from other experts. And those reports and information all show that there was no justification for Petrotrin to terminate the contract. I would also discuss with you later a PowerPoint presentation which was presented to Petrotrin and which showed that the field had the necessary oil reservoir capacity to produce the volume of oil which A&B sold to Petrotrin. I would also show you that Petrotrin's records showed that A&B had the pump with the necessary capacity to pump the volume of oil to Petrotrin, demonstrated that A&B had the capacity not only to produce oil, but pump the oil to Petrotrin. The basis of the case of Petrotrin against A&B was that its wells at the Catskill field did not have the capacity to produce the oil, and that A&B did not have the capacity to pump the volume of oil. Petrotrin's own evidence shows to the contrary, that it could have produced the oil and it did have the capacity. The information which A&B's lawyers recently saw, therefore, show beyond a reasonable doubt that A&B did not supply fake oil as alleged by Petrotrin. On the contrary, A&B supplied real crude oil, and the evidence which Petrotrin has shows that Petrotrin's case against AB is really a fake defense. And this fake defense by Petrotrin is being used to avoid paying AB for the supply of real oil. A&B has the right through its lawyers to make public the contents of the report and the information which Petrotrin has, because those reports and information show that Petrotrin knew that it did not have evidence that A&B sold fake oil to Petrotrin. Further, Petrotrin knew that it did not have any basis to terminate the contract with A&B. In addition, based on reports and information which A&B lawyers now have, Petrotrin, after the termination of the contract, had evidence to show that it had a duty to restore the contract to A&B. Petrotrin is a state-owned company, and therefore it has a responsibility to act in good faith towards A&B in its contractual obligations to A&B. It has a duty not to dishonor the terms of the contract with A&B, and it also has a duty not to use frivolous reasons to prevent it from paying monies which are due to A&B. It is important for state companies like Petrotrin, which have contracts with the private sector, to understand that they have a responsibility to honor the terms of their contracts and to perform their obligations in good faith. State corporations ought not to use its powers to prevent paying monies to the private sector which are due and owing pursuant to the terms of their contract. State companies must not use the courts for the purpose of delaying payments to the private sector in respect of their contracts with the private sector. State companies which employ that strategy are not only dishonoring their contractual obligations, but they are engaging in action which negatively impact on the private sector investment in our country, and this can also have adverse effects on the national economy. Serious questions arise about the conduct of the then board of directors of Petrotrin in its decision to terminate its contract with A&B. The board did not conduct proper and or adequate inquiries before it terminated or authorized the termination of the contract. The board acted on uninvestigated data as stated in the internal audit report, as stated in the supplement that report, undermined the findings of the internal audit report. The board ignored those findings and proceeded to terminate the contract. The board ignored the reports and information of Petrotrin's engineers and experts which were given to it after the termination of the contract, and it failed in its duty to restore the contract after its termination. Petrotrin's investigation. Petrotrin made a public statement that it was taking steps to have it report. Petrotrin subsequently announced that based on those investigations, which were done by both Kroll Consulting Limited and Gaffney Klein and Associates, these are two international companies, they decided to terminate A&B's contract. It is now known by A&B's lawyers from the information they recently that Gaffney Klein did not conduct its own investigation. Gaffney Klein instead relied on the data contained in the internal audit report to make its findings. You would recall that I said earlier that Petrotrin's own supplemental internal audit report stated that the data in the internal audit report was inaccurate and unreliable. So the Gaffney Klein report was based on inaccurate and unreliable data. But Petrotrin never told us that and never told the public that. Petrotrin has not given us a copy of the Kroll report, notwithstanding several requests we made. However, relied on the Kroll report and the Klein report for it to terminate A&B's contract, but it decided not to provide us with copies of the report. It also did not give us a copy of, but we have not seen the Kroll report. It is clear from all the evidence that the then board of directors had, when it made its decision to terminate A&B's contract, had the internal audit report, had the supplemental internal audit report which said that the data was inaccurate and unreliable, had the Gaffney Klein report which relied upon the data in the internal audit report and which was said by inaccurate. So Petrotrin Board of Directors ought to have known that to terminate the contract would have been not proper. The Board of Directors, however, went ahead and decided to terminate the contract. And during that period of time, refusing to disclose to A&B and its lawyers any of these reports and any information or report it was relying upon, Petrotrin was hiding something. It became clear to us then that there was a cover-up and that for some reason it was decided that this field had to be taken. It became clear to us then that the whole behavior of the then Petrotrin board was suspicious. I would now deal with the measurement process which Petrotrin used to measure the crude oil which was sold to it by independent contractors like A&B. I would thereafter deal with the other reports which A&B lawyers recently received, which show that after the contract was terminated, Petrotrin would have known that the data was unreliable and that A&B had the necessary reservoir capacity to supply the oil, and A&B had the necessary pump capacity to pump the oil to Petrotrin. So there was no basis for Petrotrin assuming that A&B overstated its production. The measurement process which Petrotrin used is as follows. A&B drilled the wells at the Capsule field to produce the crude oil, which is then stored in large tanks on the Capsule field. By a custody transfer process done in the presence of Petrotrin's employees and A&B employees, using custody transfer tickets, the crude oil is transferred from the custody of A&B into the custody of Petrotrin. The crude oil is then pumped through Petrotrin's pipelines to Point-A-Pay. Other independent contractors follow the same process for the transfer of their crude oil into Petrotrin's custody at Point-A-Pay. Petrotrin at Point-A-Pay measures the quantity of oil received and compares these volumes with the volumes produced by independent contractors from the various fields pursuant to the custody transfer process. Petrotrin's case of overstatement. Petrotrin's case against A&B of overstatement in the supply of crude oil is not based on any evidence to show that A&B actually overstated its production and sale of crude oil to Petrotrin. Petrotrin's case is based on its records of the measurements of the crude oil supplied, and these measurements showed large variances between the volumes of crude oil sold to it and pumped from the fields with the volumes received by it at Point-A-Pay. Petrotrin blamed E&B for this alleged shortfall, but Petrotrin failed to take into account that its own measurement systems were found by its own audit department in the supplemental internal audit report to be inaccurate and unreliable. Petrotrin assumed that since A&B was the largest producer of crude oil in the Capsule field, that A&B overstated its production, which accounted for the variances. Petrotrin did not have any actual evidence that A&B overstated its production, but Petrotrin assumed and inferred that from the variances that there was overstatement of the crude oil supply. In support of Petrotrin's assumption, Petrotrin alleged that the Capsule field, that is the name of the field which A&B operated its wells from, did not have the reservoir capacity to produce the volume of crude oil that A&B sold to Petrotrin. And secondly, A&B's own sale pumps did not have the capacity to pump the hourly volume of oil it sold to Petrotrin. So Petrotrin was saying that I'm assuming this because you are supplying a lot of oil, you are saying you are supplying a lot of oil. But I am backing that up with because I can prove that the field that you have and the wells that you have, they do not have the capacity to produce the oil that you are saying, you produce. And further, they are saying that you do not have the pump. There is no pump that you have could show that it could pump that volume of oil. So let's see what happened. Based on the report of the PowerPoint presentation, which I stated I will discuss with you later. Now, this was a PowerPoint presentation prepared by Petrotrin's engineers and experts, and which examined all of the matters in this case. The PowerPoint presentation report, which was prepared by engineers and experts of Petrotrin, and which was presented to Petrotrin, showed that the Catskill field had the reservoir capacity for A&V to supply the quantity of oil A&V stated it sold to Petrotrin. So this evidence, which is in Petrotrin's position, which we have seen, which we have access to, which we can prove before the arbitrator, which we can prove to the country, showed that Petrotrin has evidence that the Catskill field, and in particular the area of the field which A&V was operating at wells, has the oil reservoir capacity to produce the oil A&V said it produced and sold to Petrotrin. And Petrotrin has records of the pump that A&V had, because during the contract all these things were being inspected. They are processed for inspection. Record of the pump and the capacity of the pump. And Petrotrin's evidence would show that A&V had the pump capacity to pump this oil. So the foundation pillars of Petrotrin's case against A&V has been demolished and destroyed. Petrotrin's records also show that A&V at the material time used a pump with a capacity to pump over 400 barrels of oil per hour, which was more than enough capacity to pump the volume of oil A&V sold to Petrotrin. Petrotrin's case against A&V, its case of assumption, also relied on its measurement systems of the crude oil supplied by A&V to Petrotrin. And Petrotrin was relying on this measurement system to say that, to assume that A&V overstated its supply of oil to Petrotrin. But you will recall Petrotrin's own audit department in the supplemental audit report said that the measurement system was inaccurate and was unreliable, and I would show you other reports which Petrotrin got subsequent to that maintained that. AV's lawyers pointed out to Petrotrin before it terminated the contract that Petrotrin's own reports showed that the data which it relied on to terminate the contract was inaccurate and unreliable. Notwithstanding the evidence from its own audit department, Petrotrin proceeded to terminate the contract. A&V's lawyers, as already stated, recently got information, and one such information is the PowerPoint presentation also already referred to about the Catskill field. Before dealing with the reports of Petrotrin and other information which AV lawyers recently got, I would like to deal with some of the history of the matter, which showed the attempts made by A&V for Petrotrin to either show to it or to show to the court the truth of these matters. And you would see that although Petrotrin had this information when the matter was before the High Court and the Court of Appeal and the Privy Council, this information was not disclosed. The media would recall that after the publication of the internal audit report, AV's lawyers visited the Catskill field with members of the media present, and they were shown AV's large number of operating oil wells. AV's large capacity of storage tanks, AV's massive investments in infrastructure, equipment, and machinery. The estimated investment of A&V was over $1.1 billion over the last 9 years to achieve high production of volume consistent with the aggressive drilling program between 2016 to 2017. A&V, as part of its aggressive drilling program, relied on the opinions of highly qualified petroleum engineers and geologists, and the most recent surveys of the Catskill field to undertake cluster drilling programs, by which 5 to 6 wells were drilled in close proximity to each other at the same time. So when we went on the field, we saw, instead of seeing one pump in an area pumping, we saw 5 pumps at the same area. That's what we call a cluster of wells. So you had all these clusters of wells being pumped at the same time. So you would expect that there would be greater production of oil if you have a clusters of wells like that pumping at the same time, instead of having one pump, one pump, one pump, as you normally see. AV expended large sums of monies in purchasing equipment and machinery in order to extract the highest volumes of oil. A&V invested its monies in ensuring that the wells could produce oil to the maximum. He brought the technology, he brought the expertise, he brought whatever was required. And you would like to know that since Petrotrin took over the field, after A&V was put out of the field, the figures and the production are high. So the subsequent evidence, the evidence after Petrotrin took over the field from A&V, the measurement and the figures of the production of the oil in the Catskill field and the AV wells continue to be high. These 5 to 6 wells in a cluster produce oil together, and there were clusters of these wells, so you had several wells pumping and providing oil at the same time, so there was a greater volume of oil production being produced by A&V at any given time. A&V was the only independent contractor which employed the cluster wells drilling program. A&V was able to extract more oil in a shorter period of time than any other independent contractor or Petrotrin in the 70-year history at the Catskill field. That is a matter of record. It's a matter of history. A&V's contract with Petrotrin provided that any dispute between them would be determined by a 3-phase dispute resolution process. Firstly, negotiation, secondly, mediation, and finally by arbitration. A&V, in its lawyers' letters to Petrotrin, activated the negotiation phase and tried to have meetings with Petrotrin to discuss the allegations and for A&V to give explanations and answer to any questions. Whilst in the negotiation phase, Petrotrin, by letter dated the 19th of December 2017, terminated A&V's contract. We continued the negotiation stage in early January by having a meeting with Petrotrin, and at that meeting requested that the termination notice be withdrawn and for the contract to be continued until the negotiation, mediation, and arbitration phase continued. A&V was prepared to give whatever undertaking was reasonable to Petrotrin so that the status quo of the contract would have been maintained until the matter was determined by arbitration. Petrotrin refused. A&V informed Petrotrin that if interim relief was not granted, A&V would be constrained to apply to the High Court to get interim relief to preserve the status quo. A&V was advised that going to the High Court to get an injunction was a risk because the law is that the court normally does not grant an injunction in a breach of contract case where damages would be an adequate remedy. So when we went to the High Court and we went to the Court of Appeal, the court told us that if this contract was wrongfully terminated, A&V would be compensated by Petrotrin, is entitled to damages. So neither the High Court nor the Court of Appeal had to determine the merits of the breach of contract, or the merits of Petrotrin's case, or the merits of A&V's defense. All it had to determine was whether it should give an interim injunction to preserve the status quo of the parties. And the court took the position that no injustice will be done because A&V can get damages after. A&V decided to try the Privy Council. So we filed an application to the Privy Council. We did not have a right of appeal to the Privy Council, but the Privy Council has jurisdiction in order to determine, to grant leave if there is any point of law of public importance. We went to the Privy Council, we filed an application. The Privy Council gave a judgment saying, well, it made an order saying, again, not determining the merits of the matter, but what it said, there was no point of law of public importance raised, because obviously the Privy Council was taking the position that if you do not get an injunction, you can get damages to compensate you. So we had a situation, therefore, in which although A&V, its contract was wrongfully terminated, although it was suffering loss of reputation and severe damage, although Petrotrin was retaining monies, about $80 or $90 million which it owed to A&V for the supply of oil, A&V had to battle. So it was battling. So the only resort A&V had was to go to arbitration. Now those of you who do not know it, in contracts normally it provides that if there is any dispute, there's a resolution process which includes arbitration. What that means is that the case does not go to the court to determine the merits of the case. It goes to arbitrators. So that matter is now before arbitrators, and I will tell you, the arbitrators are very powerful people in this case. It's not no ordinary arbitration. The chairman of the panel of arbitrators is the president of the Caribbean Court former president of the Caribbean Court of Justice, the Right Honorable Sir Dennis Byron. The other member is the Right Honorable Lord Hope, a former judge of the Judicial Committee of the Privy Council. And the other member is retired Justice of Appeal Humphrey Stallmeyer. So we have basically a very powerful team of arbitrators. Now, I am now going to deal with some of the reports and information which Petrotrin had after it terminated the contract, which the contents of these reports and information supports A&V. There's a report known as the SGS report. That report was commissioned by Petrotrin. It's an international company. And that company was asked to review both the internal audit report and the supplemental internal audit report. The SGS report in its findings stated that Petrotrin's measurement systems of crude oil supplied by independent contractors to Petrotrin were deficient and defective. At paragraph 211 of the SGS report, it concluded, but Petrotrin ought to upgrade and modernize its equipment. And if it did not do that, it runs the risk of exposure and error and mismeasurement, both of which are expensive and can dent the company's reputation. So what this report is saying, that your system is not good. If you do not correct it, it could be expensive. That means you will probably have to pay a lot of damages for decision you made, and it can dent the company's reputation. Petrotrin had this since December 2017. They never disclosed it to A&V. They never disclosed it to the court. And we are taking steps to make it disclosed, to make Petrotrin disclose this formally to us. What this report is talking about is a measurement system that Petrotrin used to measure the crude oil sold by A&V to Petrotrin, and which measurement Petrotrin is relying on to assume and to infer that A&V overstated the quantity of oil that it sold to Petrotrin. The next matter is a PowerPoint presentation I talked to you about. This was done in September 2018. In early August 2018, Petrotrin received a document from its own engineers and experts in the form of a PowerPoint presentation labeled Reservoir Evaluation of the Catskill Field, which was updated on the 5th of September 2018. The PowerPoint presentation showed that AV's wells in the Catskill Field were in fact capable of producing the volumes of oil reported by A&V. This is Petrotrin engineering. The evidence which Petrotrin got from its own experts and engineers undermined Petrotrin's case against A&V, because the major plank of Petrotrin's case was that the wells did not have the capacity to produce the oil A&V supplied to Petrotrin. Petrotrin's own experts and engineers are now stating that the wells had such capacity. The presentation also stated that Petrotrin re-evaluated, that is the experts, re-evaluated and remapped the Catskill field, that is where the oil was being drilled, in the light of new information of the production volumes of wells previously drilled by A&V, which were being operated by Petrotrin. The remapping depicted what A&V always stated, namely that the Catskill field was highly faulted with many separate blocks and with many sands, that is, different layers of oil reservoir underlying those separate blocks. The PowerPoint presentation also showed that the portion of the Catskill field operated by A&V had a large oil reservoir capacity. The contents of this PowerPoint presentation therefore showed that Petrotrin was wrong to assume that A&V wells did not have the capacity to produce the crude oil it sold to Petrotrin, and therefore the basis for termination of A&V's contract was destroyed. When I saw this evidence, and when I saw Petrotrin suppressing the evidence, I wondered whether there was somebody at Petrotrin. I asked myself the question, is it true that somebody at Petrotrin knows the potential of this field, and therefore they would like to get it out of AV's hands and give it to them or one of their friends? Because I cannot understand, and I still cannot understand, why a state-owned company would have all this evidence and close its eyes to it and go ahead and terminate a contract, and it does not take steps to restore the contract. This remapping took place between July and September 2018, after Petrotrin took over the field in March 2018. And the information Petrotrin found through its experts and engineers is consistent with the quantity of crude oil which A&V sold to Petrotrin. This evidence alone conclusively demonstrates that Petrotrin's termination of A&V's contract on the basis that the Catskill field were incapable of producing the volumes of oil was plainly wrong. But members of the media and my fellow citizens who are listening to this, that is not the end of the picture. Let me tell you, going to something else. There was an email from Kaffney Klein and Associates to Petrotrin. You remember Kaffney Klein and Associates was the expert, the company that Petrotrin board of directors went public and said they were having an independent investigation and they were given to Kathleen Klein all the information in order to advise it what to do with this contract. Well, in early August 2019, A&V got sight of an email from Kathleen Klein and Associates, which was sent to Petrotrin. That email suggested that the data which Petrotrin gave to Kathleen Klein before Petrotrin terminated AV's contract was inaccurate. Kathleen Klein was telling Petrotrin that the maps and information now sent to it shows that the first opinion it gave was based on inaccurate information. The email stated, and I quote from the email, "Harris, about the map you sent today, that this is information that was not disclosed in our visit to, on our first report, and it has important details. I have some questions for Petrotrin. The area is strongly faulted. Are these blocks created by these faults, isolated blocks? Because in that case, the argument from the other side, that meaning A&B, about the drainage area will be difficult to rebut." That is Petrotrin's own expert, Kathleen Klein, whose reports Petrotrin did not want us to see, but we saw it, and now we are seeing the email. This email made it clear that the maps which Petrotrin now provided to Kathleen Klein and Associates, which Kathleen Klein and Associates did not have when it did its first report, had important details to show that A&B wells at Catskill Field had the reservoir capacity to supply the crude oil that A&B sold to Petrotrin. In other words, Kathleen Klein was telling Petrotrin that Petrotrin misled it when Petrotrin gave it the information for its first report, and which Petrotrin used to terminate A&B's contract. But the new information from Petrotrin was totally different to what it got before, as it showed that AV's wells at the Catskill Field had the reservoir capacity for A&B to sell the oil it sold to Petrotrin. Further, Kathleen Klein and Associates stated at paragraph 4 of its email, and it gave an opinion as to Petrotrin's measurement system, which it used to measure crude oil sold to Petrotrin by independent contractors. And Kathleen Klein said that the system is largely manual, and there was a high likelihood of measurement errors in that process. Now there are other reports, many others which we have seen, too numerous to mention. But other reports consist, and I'll explain it to you. Petrotrin has something called the Petrotrin overages reports. And those reports show the same kind of oil production in the field at Catskill, the same kind of variation. So those reports will negative any assumption or inference. It has something called, some reports called the well test reports data. We have seen some of that. And those well test report data also show that the Catskill field has the reservoir oil capacity to produce the oil which A&B sold to Petrotrin. This is a very serious matter. It is a very serious matter because members of the board, of the then board of Petrotrin, which is a state-owned company, use the position and the power of the state to take away the lawfully entitlement to A&B. And I am not making any threat today, but I have a duty to my client to explore whether the members of the board at the time did not commit the tort of misfeasance in public office. Because in my view, there is evidence of recklessness, gross negligence, and an attitude of not interested in the truth. It is very serious for state companies to deny persons their contractual rights. And it may be, I should say something about that. I would hope that the government of Trinidad and Tobago would take steps to ensure that the information which I have disclosed today and which probably the government is not aware of. I see that there's a new board of directors of Petroton, but if I were a member of that board, I would have a duty to call for all of this information and for the board to look at it. And state corporations, the government must send a signal to state corporations that they are occupying the positions in trust for the people of Trinidad and Tobago and not for themselves. Finally, the arbitrators have a decision to make in January. I want to tell you that we are equipped. We have international experts. We have requisite legal expertise available for the arbitration. And we are ready and willing and anxious to see the evidence which Petroton would call to give evidence. And we are ready to cross-examine that evidence and show to the arbitrators that there was no basis for the termination of this contract and that this is a frivolous defense being put up by Petroton to deny A&B its entitlement. This is a case in which the damages would be very, very, very large. Thank you very much, members. I can answer any questions you want.
Mr. Maraj, the leader of the opposition, Ms. Hamnak's predecessor, she bust the map that Petroton, that A.N was supplying fake oil to Petroton. From what you have said, it's a lie.
Yes, well, not only to anyone, but to anyone who contends it's a lie as far as Petroton is concerned. It is a lie that if anyone in the government thought that this was fake oil, it's a lie to any member of the media who thinks this was fake oil. It is a total lie.
Well, Mr. Maraj, what action can be taken by A.N against the leader of the opposition for putting forward that lie?
Well, there is a case pending in the courts in which A&B has filed a claim for defamation in respect of the statements made, and our case was based on the fact that this was a private and confidential report and that it should not have been disclosed, and we are saying that the publication of those words are defamatory. I am not defending anybody, but it may be that what happened is that the leader of the opposition erroneously relied on the contents of an internal audit report, which turned out to be inaccurate and unreliable.
Mr. Maraj, do you think that you're saying that about the opposition leader, but do you think that there was a conspiracy by officials from Petroton and other agents to use the info to furnish the opposition, because we all heard it first from the opposition leader, to furnish the opposition leader with this information, knowing that it was totally untrue, to discredit? Do you think that there was a conspiracy to destroy the opposition while destroying your client?
Well, that could happen because I used to be in politics and people will give you information, and if you just use it, you can get yourself in difficulties, especially if you use it outside of the parliament.
And just two questions before we continue. I realized that in number 29, 36, where Petroton took over the field in March 2018. Now, when they took over the field and they had terminated the services of your client, but when they took over the field, you said based on your investigation and your report, that they were making almost similar to what AV was making after, with respect to the 48 wells and whatnot. But tell me something. If AV being the contractor, they would have had to employ, because I believe that there are about 40 something other contractors. So then, is it what was it that they had to get rid of AV, seeing that he did all this work? So who are the contractors? Would you tell us, if you maybe, I believe you will have that information, that who are the contractors that replace AV?
No contractors replaced AV because Petrotrin kept the field for itself.
Uh-huh.
But Petrotrin was drilling oil.
But how I heard personally that there were attempts to bring in friends.
It may be, I also heard certain things,
Okay.
and it may be there was a plan
Uh-huh.
to bring in other people, but we were very aggressive because if, for example, Petrotrin had given that field to another contractor, remember in our claim for damages, that would have heightened the claim,
Right.
because the tribunal has the power to make orders that it considers fit. So the tribunal can make an order for damages. It can also make an order for him getting back the field, for Petrotrin taking.
And what about his loss and everything?
Oh yes, yes,
But could you tell us, I mean, you might want to disclose figures, and you said in closing that the damages will be great. You want to give us a little idea about the damages?
We're talking in terms of about $1 billion.
$1 billion. Okay.
This is
Manoj,
this is a major claim.
Thank you.
Manoj, you're
Yeah.
talking big bucks here. Is there any truth to the rumor that you're working pro bono?
But I don't think that question should really arise in this matter. What I can tell you is that I feel very strongly about this case. I feel as if this was an injustice to me, and it is not unusual for me to feel that way in respect to some cases. And since I consider it to be an injustice to me, I suppose I have a lot of passion, extra passion for it. And that is only human. But I would ensure that A&V and Mr. Bax get the justice they deserve.
Senior, we are live, everybody's watching all over the world. But one question somebody now sent me is that now in your field as a senior or a prominent thing, you're a very distinguished man.
Oh, thank you very much, sir.
But in the field with in the area of Petrotrin, is Gaffney Klein a distinguished organist, that individual, that you know.
Yes, Gaffney Klein is a
Reputable
company. It's a reputable company, and I think that probably explains Gaffney Klein's.
request for more information.
Well, it explains Gaffney Klein's email in the way they said that.
But do you think that Petrotrin, as we say in local parlance, they try to chain up Gaffney Klein and furnish Gaffney Klein with false information?
Well, you have to understand the position Gaffney Klein was in. And Gaffney Klein made it clear that it was relying on the data Petrotrin supplied.
Well, then the documents said that Gaffney Klein realized that he was foolish. He
Yes,
didn't get proper
because
information.
they realized they were fooled when Gaffney Klein.
In closing, with respect to the quick questions I have here, you said damages after the arbitration. How long that process takes?
Well, this is a very powerful team of arbitrators, and I think that we will get a very quick judgment in this matter. The arbitration will be heard in January, and I think by the month of March, we will be able to.
Based on the findings and whatnot. Thank you, sir.
Mr. Morat, you mentioned that you did not see the Kroll report. Right. Now, how can you then be certain that the Kroll report was not an independent investigation?
I am not saying that the Kroll report was not an independent investigation. I am not saying that the Klein report was not an independent investigation. What I'm saying that the information which Petrotrin gave to Klein, although it's a very reputable company, it showed that they were limited because they acted on inaccurate and unreliable data. I do not know whether Kroll got the same data. I haven't seen the Kroll report. I do not know what is the Kroll report says. But all I can say is that even if you have the Kroll report, you have other reports now which show that one, the field has the capacity to produce the oil A&V said it produced. The Petrotrin records have the pump that has the capacity. The measurement system is flawed and cannot be relied upon. So I cannot see how Kroll could help in this in any event. But what I do not understand, and there's a principle of law, is that if I suspend someone or I terminate a contract on the basis of the contents of report, I have a duty to make that report available. If you are refusing to make that report available, the law says that the court can draw an adverse inference against you, that you have something to hide, and that the report does not support you. And the court can find that the reason that you did not make it available, and you do not want to make it available to the court, is because the report does not support you. So the Kroll report cannot assist Petrotrin at this stage, having regard to the totality of the evidence from Petrotrin itself, from Petrotrin's experts and engineers. That is why I could come before you today and say that I'm 150% sure that there could only be one result in this case. And the persons who are going to judge this case are persons who have long history. Lord Hope is one of the most eminent jurists in the Privy Council. Lord Byron is also one of the eminent jurists in the Caribbean. When you read his judgment, he does not make joke when he sees unfairness and injustice. Lord Hope is not going to tolerate unfairness and injustice. And I have no reason to believe that Justice of Appeals Tolmaya would tolerate unlawfulness, unfairness, and injustice.
Is arbitration the final legal step?
Sorry?
Is arbitration the final legal step in this matter? Assuming, of course, the court doesn't go one way or the other. Is this the end?
Well, I think it's the final step, but there's a school of thought which says that if there's an error of law, the Court of Appeal has jurisdiction. Only on an error of law. But that's the end of the matter. But Mr. Warner is so happy to see you. Like my brother, man, I haven't seen you a long time. Anyway, Mr. Warner, as you know, any government which has a judgment from a tribunal like that, which would paint the picture, which must paint the picture of the evidence, it would not be politically wise for such a government to allow a state corporation like Petrotrin to pursue such an appeal.
These are difficult times.
No, I know I agree,
normal times.
but I still have confidence. Any more questions? I must say thank you very much. I thank all the members of the media for coming. But it's a long time I did not see Mr. I.A.N, and it's a long time I did not see my brother Jack Owen. So I'm happy to be here. Thank you very much.
All right, Mr. Maharaj, we just want to get a photo of the lawyers that you had just now, the Prakash, Mr. Singh, and Ronnie. And we saw, we observed that Mr. Baksh was in the background. You can't bring him in as much as this is in as much as he's around. And this
Mr. Baksh doesn't like the camera.
Okay, Ronnie. We just want to get the lawyers that he listed just now. They'll take the names of the order. You want to use the microphone here? Right, yeah. Right, back up. No, no. Yeah, right.
Right, that's it.
Okay.
The only person missing is I'm right around, you know.
What do you think?
You got very careful.
Well, just again.
Well, ladies and gentlemen, ladies and gentlemen, here for the report, the findings of the spoke to Mr. Mirage, and so we're going to wait on the arbitration, but it's very, very interesting information that was furnished to us today. And you can recall that a couple of days, well, in fact, the entire last week, we've been talking about it, just talking about it, telling you, look out for it, look out for the information with A.N. It's interesting. It's very, very interesting. And I mean, nobody can deny there was a conspiracy to terminate AV drilling. And I mean, all the information coming out, all the auditors report and whatnot, they realize it carries truth that there was no fake oil. And it's just as I said, that the truth will have come out eventually. So we're just gonna wait. I mean, just like yourself, we're just gonna wait and just like myself, we're just gonna wait and see with respect to the arbitration and whatnot. And yes, so this is I.A.N at Ramesh Lawrence Mara Senior Counsel's office, and as you can see, members of the media, my good friend here, really, really super great guy, super great guy, you know. Just chatting with Dr. Mara, Dr. Singh, Prakash Ramadar. Okay, so I'm going to take it out from here, and stay tuned for Monday. I'll be back, and whatever you have any more information, you can WhatsApp me on 294-4081. This is I.A.N. Thank you.